guys, welcome back to the Legal Queen channel. My name is Tracy, family law solicitor. Today you are going to join me on a live Discord session that I've done, listening to real people's problems and queries, all centred around family law. It might be that they're having difficulty seeing their children, or perhaps they don't know what they're entitled to as part of the financial settlement from the divorce. But ultimately, these are people who phone in to my live show on Discord, and I thought that you would get something from it if I shared it with you. So sit back and enjoy.
Yeah, I can hear you.
Oh, lovely. How are you?
I'm doing good. How are you doing? Nice to see you live.
I know. I thought I'd jump back on again. It's been a while, hey?
I know. But I think all the mods are doing anyway, so...
Oh, bless. Oh, that's good. Well, we're going to make it a regular thing.
I'll catch up with you in a bit.
Okay, thanks, Mark. Appreciate that. Speak to you soon. Bye. Quick question on the Instagram. Can you ring fence equity when a new partner moves in? No, you can't ring fence it, but just know... I can't see who's asked me that question, but just know that you don't mingle finances, okay? As long as you don't mingle the finances, then it will be absolutely fine. Obviously, if you get married, that changes the whole landscape of things. But if you're just living together, then make sure that you keep all the finances separate. That way you don't have to ring fence the equity. If the house is going into joint names and maybe you've paid more of the deposit in, maybe that's the question you're asking me, you might want to think about getting a deed of trust, okay? Captain, you are first with your hand up. So whenever you're ready, hello again.
Hello, I can hear you now.
Excellent. I'm very good. I know it has been a while, but we're back. There we go. We've got a whole production going on. We're live on Insta and TikTok. We're recording it all for the YouTube, so we're back in business. Did you go on?
Sorry, go on.
I was going to say, do you have a question?
Is this time going to be a regular time?
I think it will. You know,
have you got a regular time yet?
Haven't yet. I mean, I will advertise it, but we'll definitely go back regularly. I think the daytime might prove better, particularly during the summer holidays, and it certainly works better for me. But yeah, we'll have a little think after this session today. I'll do my usual hour today, and then we'll have a think.
Okay, I won't be able to join you for all of it.
That's all right. That's all right. Did you have a question for me now?
So, I did. I've got a couple actually come flying through.
Okay.
So, first question: if I'm buying a property with my dad through mortgage without my mum, will my mum have any legal rights towards the property? She gave me some money towards a deposit, and the lender expects her not to live there. But if they're married, wouldn't she have occupancy rights? Also, would I be able to still add her on the deed, and for her to split my dad's share?
What was the first bit of the question again, Captain? Sorry, I missed the first bit. Who's getting what?
So this person's buying a property with her dad through a mortgage without her mum.
Right. So and the question is, will the mum be entitled to any of the property?
Yes.
Yeah. So if dad is named on that mortgage, then he is a legal owner of that property. And if mum and dad aren't divorced, then mum's entitled to dad's share, or a share of dad's share. So if they don't want mum to have a claim to it, then dad must make sure that he's divorced, but more importantly, that he's got the financial order in place. And that way, he's severed all financial ties from mum.
Okay. No question. Can I apply for a change of name and travel out of the country together, or is it a separate application? If it's a separate, will it be two separate court hearings?
It will be heard at the same court hearing, but it's two separate applications. So the change of name is a Form C1, and to travel outside of the country if you don't have the other parent's permission is a C100. On the C100, you're asking for the specific issues order, and the C1, you're asking for the name change. But you can submit them both to court together, and they'll definitely be heard at the same time.
Yeah. Okay. Thanks, Tracy.
Brill.
And then the last one I've got today is, please could you ask Tracy, my ex-husband has applied for a financial remedy, and in it he wants maintenance in sue and a lump sum order. What are these, and should I reply asking Why?
So maintenance pending suit is a fancy way of saying spousal maintenance. The pending suit part means pending the divorce, the suit of divorce. So he's asking for spousal maintenance, which is maintenance for himself. It's exactly the same as child maintenance, but it's for the spouse. And a lump sum order is just that. It's a lump sum of cash. Perhaps he's looking to sell a property that they've got and he then wants a lump sum from that property. Or perhaps they've got savings and he wants a lump sum from that savings. So that's what that means.
Okay.
All right.
Thanks. That's all I've got, Trace.
Pleasure. Thank you, Captain. Speak to you soon.
Bye.
Bye. Lauren, you are next, waiting patiently with your hand up. Thank you so much. There's a lot of hands up now in the Discord lounge. Whenever you're ready, Lauren, you can join me on the stage and ask me your question. While we're waiting for Lauren, I'm going to come to Antsy 3138, whenever you're ready. Lauren, it might take you a little while because I can see that you're new to Discord. Don't worry about that. Oh, there you are. You're on the stage. How can I help, Lauren?
I wasn't sure how to do it.
It's fine. You've done it perfectly. What's your question?
It's a bit of a long-winded story. I have a
Okay.
12-year-old daughter with my ex.
Yeah.
We have 50-50 custody. We have had that since she was 4, so it's 1 week on, 1 week off.
Yeah.
We both lived in the same area, so she went to the same school. About 4 years ago, he moved to a different area.
Yeah.
She remained at the same school.
Yeah.
I am now moving to a new area, which is actually a lot closer to him, so it's like 15 minutes in distance. But he won't let me move her to a new school.
Okay.
Is just outright saying no. Wants her to stay at the same school that she's at currently, even though neither of us live in the area. And for me, it would be on my weeks, it'd be 140-mile a day round trip.
Okay.
So I have applied for a new school for September in my local area, even though he said no.
Yeah.
I'm just like, where am I at legally? Will he take me to court, and can they make me send her back to the other school?
Well, I don't know if he's going to take you to court, but I think what you need to be clear about is that I take it Dad has parental responsibility, yes? He's named on the birth certificate.
Yes. Yeah, he's got parental responsibility. He's got 50-50, but he doesn't adhere to his 50-50. So I probably have her 70-80% of the time because of his work commitments. Like, he'll go working away and doesn't come back for his time.
Okay.
He doesn't do doctors. He doesn't do dentists. He doesn't do opticians. He doesn't do like parents' evenings, sports aid, anything. He doesn't do anything.
Sure.
I do the lion's share of everything.
Okay.
But he wants to dictate the school.
Fine. That's good to know. However, it won't really have an impact on the question that you're asking me. So know that. And I say this, Lauren, just for everyone else that's listening. If you share parental responsibility with the other parent, so both of you have PR, the three big ticket areas that you have to have agreement on is medical, education, and religion. So the fact that you want to move your child to a different school and he's saying no means that you can't legally do that without his permission or a court order. So if he's, stamping his feet and saying absolutely not, the better course of action for you to take, rather than just up and doing it, is to make an application to the court, asking the court for an order that you move your child to that school. Now, you've got some factors on your case that gives you a good case, i.e. the travel. That's a long way to travel for the child, if nothing else. But
yeah,
I
have another child as well, obviously, that I need to get to school as well.
Fine.
My job.
But I don't know what he's going to argue on his side. He might say, well, actually, the school that she's currently at affords lots more opportunities, blah, blah, blah. I don't know. But what I'm
his
saying...
His only argument is that his support network, or where I currently live, where she's always lived before we move, that's his support network, but he doesn't ever utilise his support network. This is just a new thing because I've always been, his support network.
Yeah.
We've been there, when he's been working away, etc. Now all of a sudden he's got this support network that he needs, but he doesn't ever uses.
Yeah. I raise it simply because, again, just know that the court will want to hear from him as well. So then to answer the second part of your question, if you were to just move the child without his permission, could he then take you to court and move her back? Absolutely, he can take you to court. Would he succeed in that application? I don't know. The court's then going to come down to what's in the best interest of the child. But what I would say is it's probably going to stand you in better stead if you didn't do the move without getting the court's approval. So make the application. C100, specific issues order. Just tick the box for a specific issues order, okay?
Okay, perfect. Thank you very much for your
Thanks,
help.
Lauren. Okay, bye.
Thank you. Bye.
Ansi, you are next. Whenever you're ready, what's your question? Antsy? Oh, you're on mute. Oh, I can't hear you. I'm so sorry. Let me drop you down back into the lounge, Antsy, and I will put your hand up and I'll bring you back to the top of the queue. While I'm waiting for that, ABZ, you are next up. What's your question?
Hi, yeah. So I have a quick question. So I recently lost my job there last month, and my child maintenance has dropped down to £25 a month from 380 odd quid. So the last time I was actually supposed to see my daughter, or I did see my daughter, I had everything booked. I took her to Knowsley Safari Park, rented a car. I came from Northern Ireland over to England to see her and everything. And my ex-wife, the night before I was actually supposed to travel, she actually turned around and said to me that if I don't purchase my daughter's school uniform for next year online, then she wouldn't be coming to the contact, and I wouldn't be able to take her to Knowsley Safari Park. Unfortunately, at that time, I was sort of in a rock and a hard place, and I had to sort of I had to basically pay that money so that my daughter wasn't missing out. So she obviously knew that we were going to the safari park, but I kind of seen that as a bit of blackmail. Would you say that that is something that could be taken to court for, or what would your suggestion be?
I mean, look, I'll agree with you. It definitely is blackmail. It's emotional blackmail, if nothing else. The order that you have at the moment, does it say anything about you paying for uniforms or extracurricular for the child, anything like that?
Nothing at
No.
all.
Okay.
The order actually says that I see my daughter once a month, at the first Saturday of every month, and then it's supposed to be a second visit as well. Now, it doesn't say anything in relation to finances or anything like that, or who pays, etc. But right now, I can't afford to go and see my daughter the second time of the month because I'm not earning any money.
Sure.
So it's holding that against me as well.
Yeah. So yeah, I mean, absolutely. It's not then. She hasn't technically breached the order. You know, she's asking you for money, and you are saying that you gave it to her on that occasion to allow contact to go ahead. If, however, she pulls that stunt again and you haven't got it, or you just don't want to pay it because you're already paying the child maintenance, and then she doesn't let the contact go ahead, then you've got a breach, and then you can take it back to court. But right now, the order says you have contact once a month and that she's to make the child available, and she's doing that. So you'd have to wait until she stopped doing that before you could take her back to court. Because by asking you for the money, she hasn't breached anything. Do you know what I mean? She didn't get...
But she said directly she wouldn't be coming if I didn't pay that. So that was where I was stuck. Like, I had spent about £200+ to rent a car, to go to book Knowsley Safari Park, my flights, my accommodation, everything was booked. And for her to turn around and say, right, she's not coming. Unless you give me this money.
I appreciate that. No, I do appreciate that. But legally, she didn't stop it. You'd have to actually wait until the breach occurred, because you wouldn't succeed if you were to go back to court and say to judge, well, she threatened to do it. Because judge would say to you, yeah, but did she actually do it? Well, no, she didn't do it, but she just threatened to do it. That's not legally a breach. So as difficult as it is, you'd have to wait for the threat to become a reality. So you actually missed out. You turned up, the child wasn't made available, you had to go home again. There's a breach. But up until this point, there is no breach. But yes, once she's breached it, you can take her back to court then.
Okay, perfect.
All right.
And just in terms of that the second part, where the order actually says that a second visit after, I think it was 4 months, we can do 2 visits a month.
Yeah.
Unfortunately, I can't financially afford that now after having lost my job.
Yeah.
She's holding that against me, saying that I'm in breach of the child arrangement order, etc., etc. Do you think the courts would look negatively on that?
No, I think the thing to do is preempt an attack, if you like, and I don't mean to sound aggressive, but preempt the fact that she may then start to make noises or take you back to court. And the preempt there is to send her an email to say, I appreciate that in a month or 2 months, however long away it is, I will be able to have 2 visits a month. However, In my current situation, I'm unable to travel from Northern Ireland over to England to have that second visit. So until further notice, I'll have to keep it at one visit. Now, if you email that to her and then she takes you to court and she says, oh, you're breaching the order, and you're able to show that email to the judge, common sense will overrule there. You know, common sense will apply, and the judge will say, well, look, it's not because he doesn't want to have contact with the best friend in the world. He just simply can't afford to do it at the moment. I'm sure that once you get back on your feet again, you'll be able to, you know, have that second visit. But make sure you send her an email and that you've got that evidence to hand if you need it. Okay?
Perfect. I will do.
Fab.
And then just one final point.
Yeah.
She actually so basically I've brought my daughter to Northern Ireland twice. I think once was in November, once was in January this year. And since then, she keeps saying to my daughter, do you want to go see your dad? Do you want to go see your dad, spend time with your dad? Unfortunately, I had to stop that there and then because she actually sent emails to social services with all these false accusations in relation to my family, myself, how my daughter was treated, etc., etc.
Yeah.
So I have to put a stop to that. And even whenever I video call my daughter, she keeps saying to her, oh, would you like to go see your daddy over the holidays? But I actually feel that is a reason. Like, she wants me to have a longer period of contact with my daughter so that social services can get involved. Over a weekend, social services aren't going to directly get involved unless there is serious threat to.
I understand. Yeah. So what's your question of me?
So what would you suggest in that aspect?
Just stick to the order. You've just got to stick to the order. You know, if you know that the other side is game playing and they're unable to co-parent, just stick to the order. You know, you stick to that more rigidly than it's a shame because, you know, the court orders are always open for parents to co-parent and to extend contact if both parents are in agreement, but not to game play. Okay, so you just need to stick to the order there.
Okay.
All right, lovely. Well, I hope that's helped. Pleasure. Bye.
Thank you. Cheers. Bye-bye.
Ansi, let me come back to you. Hopefully I can hear you this time. Hello? Oh, Ansi, I'm so sorry. I still can't hear you. And I know that something's wrong because you appear as a little box and the green light goes around the box if I can hear you and I can't. So I'm going to drop you back into the audience again. Alice, what's your question?
Hello. Can you hear me?
I can, loud and clear.
Oh, brilliant. I'm asking on behalf of my sister. She's separated with her husband.
Yeah.
They've got 2 children together. They have divorced, but they haven't severed financial ties yet.
Yeah.
She's filled out, I think it's the statement, information statement or something for a consent order.
I know what you mean.
Yes, he's been in the military, so is unable to have previously gone 50-50, but is now kind of saying he wants to go 50-50 with the children, is moved closer.
Okay.
So they have been able to potentially do that. There's been quite a big argument between my sister and her ex-husband on how that's going to look going forward. He's stating that he wants to do 1 week on, 1 week off. She's saying she's single still. He's found a new partner and is living with her and her 2 children. My sister has said she's unable to do that because actually she needs to continue to work. So I think over a 14-day period, she would only see the children kind of 3 or 4 days. And we were just kind of wondering what her potential legal backing is of that, because he's quite adamant that is what is happening, whether she likes it or not.
Okay.
He's been quite, I would say, a bully throughout the whole relationship. And he's also stating that the second they go 50-50, he'll be stopping all maintenance.
Yeah.
So I'm not sure whether they've had their maintenance privately agreed.
Yeah.
So I don't know if you've got kind of any advice on what she can do going forward.
Okay, well,
process isn't too scared to go to a solicitor, basically.
Yeah. Okay, let's start breaking it all down, because there's lots of elements to that question. So the first part of your question was you were referring to the D81. And again, I'll explain, Alice, just because others are listening as well. So when we submit a financial order to the court, there's the order and there's also the D81. And the D81 is where we put all the admin information down. So where the parties live, how old they are, how long they've been together, what they're earning, what debts they've got, and how they're going to separate that money as part of the financial settlement. So I suspect what's happened is he's received the D81 and then maybe thought, actually, if I have the children 50-50, then I won't need to pay her maintenance and I won't need to move away from a 50-50 divide, pension-wise, etc. I don't know what he's thinking. But generally, that's when it comes up. We get almost to the finish line with the D81 and then the other party starts to say, well, hang on a minute, we haven't sorted out the children. So that's the first thing. That might now need to be paused, Alice, until we do sort out the children. The children issue, that's going to come down to what's the routine the children are used to. So if they have always lived with mum and had contact with dad, and mum and dad cannot agree, the matter will go to court by way of a child arrangements order, and the court are going to decide, well, what's the children used to? What's the status quo? So dad may struggle to win his 50-50 argument. It's not for dad to decide. You know, when you were telling me the story there, Alice, like, well, dad says this and dad says that and dad insists on this and he's going to do that. It's out of his hands because both parties have got parental responsibility. So they come to the disagreement with equal amounts of rights, powers, responsibility, call it what you will. So if your sister doesn't agree and the matter goes to court, the court's going to then say, well, look, what are the children used to? And if they've lived with your sister, chances are that's the order that's going to be made, just to provide consistency with the children. Now, obviously, my answer is generalised because sometimes we have older children, 12, 13, 14. And in that scenario, the court might then say, well, let me hear from the children. Not directly, they'd be heard through social workers called CAFCAS, but let me hear through the children as to what their wishes and feelings are. So if there's no agreement, tell your sister to make the children's application using the C100 form.
C100. I'll
C100.
ask her to do that.
Yeah,
because he's only had them since they separated. He only has them every other weekend.
I see.
So he was focused on his career rather than kind of having the children more. And then he's kind of said, it's happening from September. I'll be stopping all child maintenance. You will not receive any further funds from me. And we will be going forward with the 50-50.
So again, Alice, he doesn't have the ability to dictate like that. So if that isn't the appropriate settlement, then unfortunately we're back to court with a second application. And this time it's a financial application. And that's kicked off with a Form A. Now, all of these forms that I talked to you guys about, you can download from the government website. So the C100 is to start the children's application, and the Form A is to start the financial application. Basically saying to the judge, look, we're going through a divorce. These are the assets that we have. We can't decide how to divide them. The wife says this and the husband says this. We need the court to intervene and the judge to help us, by way of an order. Okay, so that's what she needs to do. Now, I always say this, Alice, and if you follow me regularly, you'll know. Before your sister makes that financial application, tell her to get some legal advice, even if it's just a one-off hour with me or with somebody else in my firm, because that's really important that she knows what she's entitled to financially before she makes that application, okay?
Yeah, I think this is where the issue, she's not got any until she had a 1 hour meeting the other day regarding going 50-50 with the children, but they've almost already split all their assets. They sold their property, and and she's moved out and done all of this, and she hasn't had any legal advice at all on the assets at all.
Okay. It's not too late though, Alice. It's to tell her it's not too late. You know, unless the money's gone, or you know, it's all sort of been placed on red, or it's all burnt. You know, it's not too late. Okay, so she still needs to get that advice. All right.
And sorry, very last quick snippet.
Yeah.
In regards of going 50-50 in maintenance, do you know potentially would she still be entitled to some maintenance because her wages are significantly less than his, and he's been living with a new partner for more than 6 months together?
So that's gonna, Alice, that's gonna definitely impact upon the financial settlement for sure. But directly to answer your question about the child maintenance, that is a far better question for CMS, because as family solicitors, we don't really get involved in the maintenance side of things. But the fact that he's in a new relationship, a new cohabiting relationship, and the fact that your sister's on a much lower wage than him are two significant factors that will definitely impact her financial outcome. But CMS, it's best that she talk to them.
Lovely.
All right.
Fantastic. Thank you
Pleasure.
so much for your help.
No problem. Thanks, Alice. Bye.
Thank you. Bye.
But I just wanted to say, guys, there's so many questions coming through on Instagram and TikTok. Your best bet, though, is to come over to the Discord. So if you download the app and create yourself a profile, the link's in my bio, come into the Legal Queen Lounge and pop your hand up. Because obviously it's difficult for me to read the questions and answer them, as well as sort of look after people that are in the queue. So if you've really got a pressing question, you don't want to send me a DM, come over to the Discord. I'm going to be here until 1:30 today, okay? Speeds, what is your question?
Hello again.
Hello.
We spoke a couple of months ago.
We did. Yeah, I can hear you loud and clear. Yeah, and I remember your name. We did speak.
Yeah, so this was about mediation and her not wanting to do it.
Yeah.
Long story short, trying to make this real quick, that she finally did it. We did a mediation session last month.
Good.
Next one is tomorrow.
Okay.
Well, I wish it was good, but it wasn't. Because just as I expected, she just came with all these crazy demands. Because obviously you highlighted to me that obviously the house is in our name, both our names, regardless of how it was acquired, it is in our name. So, you know, it will be split unless we can get an agreement. She's going to mediation saying that, you know, I want half, that's it, don't really care. And then in addition to that, she's saying that I can only see my child every other weekend and once or twice in the week, which is obviously quite ludicrous considering we still live in the same house. So I see my son every day. So I've been trying to do some research, and one thing I've heard about, which is what I want to ask you about, is matrimonial
home rights. Matrimonial home rights.
Home right.
Yeah.
Yeah, because she's got a place in a different country.
Yeah.
So I wanted to find out if I can do that, and what do I need to do to be able to do that?
Okay, so obviously you're bordering on advice, and I can't give you advice per se, but what I can do is give you some tips, if you like. So I'll ask a couple of questions, but obviously I don't want this to, you know, cross the confidentiality line. I take it you guys aren't married.
We are.
You are married.
Through the process.
Oh, okay. Okay. So the financial settlement then, when she's saying it's going to be split 50-50, that's not necessarily true. And the reason for the HR1, as we call it, or the home rights notice, is that because the house is just in your name. So she's lodged that.
The house in the UK is in both our names.
Yeah.
The house in the other country is in her name only.
So who's lodged the HR1? Are you thinking about doing it?
I was thinking about doing it.
I see. Right.
Country.
So then you'd have to go to the other country or speak to a lawyer there and say, what's the equivalent to the HR1 there? Because the home rights notice is only, it's only for England and Wales jurisdiction. So I'm sure that the other country has something similar, but you would need to clarify with them what that is. Now, even though that house is outside of the jurisdiction, we can still include it in the financial order. Don't think that we can't. And absolutely, we can include the equity in it. We can factor the equity in it, etc. But the HR1 was going to be different in another country. So that's that. Now, the children's issue, pretty much what I said to Alice, that's going to be a different application. It will be a different hearing completely, because you have parental responsibility, which means that you both share the same rights and responsibilities towards that child or children, okay? And, you know, what people sometimes forget, or what parents forget when they're arguing with their ex, is that actually the law's very clear in that it's the child's right to have a relationship with both parents. So if she is depriving the child of having a relationship with you, she's depriving the child of that right. Now, you would kickstart the application because you're the one that wants more contact, or contact in a different framework to what she suggests is suitable. And that's the C100 form. And you tick the child arrangements order. Court fee is £232, and you're going to email it to the court nearest to where the child lives. Okay?
Okay. With that, do I do this like now, or do I wait till mediation kind of ends or finish? Yeah.
Well, that will depend on how mediation's going. I mean, if mediation you think is working and it's bringing about a resolve, then fine, keep going with the mediation. But if actually mediation isn't working, then you might want to think about making that C100 application now. The reason I say that, Speeds, is because it's going to take 3 months for the court to give you a hearing date. You know, you're not going to make an application today and then get before a judge in a couple of weeks. It's going to be 3 months. So sometimes what I say to my clients is make the application so that we've got that date in the bank, and keep going with mediation. Now, if mediation works, we can then send the agreement into the court and say, we've got a date for 3 months, Judge, but actually, here's the order. We've all agreed, it's all settled. And the date just comes out of the court diary. So you haven't really lost anything. But of course, if mediation doesn't work, at least you've got that date in the bank.
Yeah, okay, because that's what I'm kind of wary of, because the next mediation is tomorrow. If she's still going to continue to say, you know, this is what I want, this is what I want, and not really to negotiate, then I now need to do this.
Yes.
To actually, you know, start the process, because this is ridiculous.
Yes. No, I agree with you. And definitely. And you see, the children's outcome is also going to have an impact on the finances. Okay, so we can't talk about one without it having a direct impact on the other. So if the children's is generally where the focus begins, and if we can't get agreement there, let's think about making a court application.
Cool. All right, then. Thank you very much.
Pleasure. Okay. Good luck with that, Speeds. Speak to you soon.
Thank you.
Bye.
Bye.
Right. C Doodle, you are up next. Whenever you are ready, ask me your question.
Hello.
Hello.
It's a pretty long one, to be honest. We'd be here for a while if I told you the whole thing of it.
Okay.
But basically, me and my baby father, we've got family planning has been involved, and we've got some bits in place for what we actually want to have with shared custody and things like that.
Yeah.
But he has threatened in the past to take my son away from me, and I'm scared that he's going to do it again if that makes any sense. But I was just wondering, like, what kind of legal standpoint do I have to anything that I could do if he does do that again?
Yeah, so I think what you need to put in place, because it's a genuine concern, it's been realised, in other words, it's already happened, is what we call a prohibited steps order. Okay, so you're downloading the C100 form from the government website, and you're ticking, because you can apply for 3 different types of order on that form. The one you want is prohibited steps. And what you're saying to the court is, please give me an order that he doesn't remove the child from my care unless I give my permission, or unless the court orders it. And the court will always grant those orders, particularly in your case, because actually it's already happened. And that's not in the child's best interest. You know, we've got to co-parent. We've got to be in agreement with how much time the child's spending with each parent. So that, I think, is going to be the remedy for you, the PSO, or the prohibited steps order.
Right, okay. I just want to write that down so I have it?
Sure, yeah. Yeah, so C100, prohibited steps, And then what you're going to do, I'll just keep saying this while you look for a pen, you're going to file that in the court nearest to where your child lives, which is obviously nearest to where you live. And there's a reason for that, in that the court may want to instruct CAFCAS to help out with this. So we want to make sure that the CAFCAS officer lives close to the child as well and is able to attend court. The court fee when we're issuing a C100 is £232. So £232, unless of course you qualify for fee remission. If you qualify for fee remission by completing the EX160, then you may get it for free. You may not have to pay that court fee. So I hope that helped. Did that help, C Doodle?
100%. Yeah, I'm really sorry, but could you just say what it is exactly that it's need to do one more time?
It's fine. C100 Prohibited Steps Order.
Yeah. Okay, cool. That's brilliant. Thank you so much.
Pleasure. All right then. All the best. Bye.
Thank you. Bye-bye.
Okay, so I have invited Tuckerus up to the stage and Doodle and Mickey 2000. It's obviously taking a little while. The three of you are all going to land at once, I know. There we go. Mickey 2000 is on. What's your question, Mickey?
Just a really quick one in relation to the financial order that we put in.
Yeah.
You've mentioned before on certain times we've spoken about when you get married, you're actually entitled to look at the pension share. So you said before that if you move in with a partner and then you get married once you moved in, that's when the kind of the clock starts ticking.
Yes.
But when does it actually end? Does it end when you actually leave the marital home?
No.
Or does it end?
So it will end when you get divorced, because until you've got that the final order, or if you're on the old system, the decree absolute, you are still legally married. So as long as you are still legally married, so if you've been separated for 10 years and you're still not divorced, you're still entitled to a share of that pension. Okay? So it will end, the entitlement to a pension will end as soon as you get that divorce. So when your marriage is ended.
So is it right in saying that they put a contribution in and it's 50% of actually what was put in from the day you moved into the actual decree absolute then?
Well, yes is the answer to that. But of course, we might not be taking 50%. Let's say I'm acting for wife. Yes, we are entitled to 50% of husband's pension, but I'm not going to take 50% if wife's already got some pension. It might be that actually, when we balance it all up, I only need 30% of husband's pension because you've got to remember that husband's also entitled to wife's pension. So effectively, we're adding the pensions together and we're dividing by 2. So if that means then that I just need a top up to my client's pension, I might not be asking for 50%. Does that make sense?
So it's it's both parties' contributions divided by 2.
Yes, essentially. Now, obviously, we're going to be ring fencing as much as we can, any premarital contributions, or in that case, pre-living together contributions. But yeah, that's definitely the starting point, the 50-50, for sure.
Brilliant. Thank you for your time then.
Pleasure.
Bye.
All right, thanks. Bye. So, Tuckerus, you are up next. Let me just take you off mute. What's your question?
Afternoon, Trace. This
Hello.
is a child matter, so I'll be brief.
Okay.
There's a current child arrangement order in place since May 2023 for my 4-year-old daughter.
Yes.
So there was no contact for 2.5 years.
Yeah.
I did a child application when she was 5 months old, but I withdrew due to some allegations that was made, and I never had no legal representation at the time.
Okay.
Anyway, so 6 months after that, I went and made another child arrangement application where contact was granted by the court, where I only have 5 hours alternate Saturdays at the moment. And it stated in the order that to mediate for progression of contact. I did ask the court for a step.
Say that again. Sorry, that last bit you dropped out. You asked the court for what?
It's a stepped arrangement, as in to progress.
Oh yes,
contact.
yeah.
So from say 5 consecutive 5 hours alternate Saturdays consecutively, and then working it to say about 8 hours on a Saturday consecutively for say 4 or 5, and then including Sundays.
Yes.
So what I did, I made another application because I tried to mediate with the mother in February this year, and the mother refused.
Yes.
So I did a 700 application, and I also did a specific issues order for a double barrel change of name.
Yes.
Which I did previously, but the judge dismissed it at the time because it said it was premature and for the parents to mediate on change of name and leave it for the parents.
Okay.
Unfortunately, the mother doesn't agree with the double barrel name. So I went into court on May. My application at the time, so the judge dismissed my application for alternate weekends, saying that I was being premature yet again because you never gave the mother enough time to mediate, which I believe I did because I had I had 5 unsupervised contacts with my daughter for 5 hours on a Saturday. There's no supervision whatsoever.
Sure.
So all I wanted was alternate weekends.
Yeah.
So the judge has now, so he dismissed my C100 and he also dismissed my the change of name for the second time.
Yes.
Saying to mediate.
Yes.
So Kafkas stated that October, due to the school and that, so not with September, it can be a busy time of year. So Kafkas recommended saying October for progress contact. The judge did see my
You've dropped out again. Oh, I might have...
And even the judge says...
Yeah.
What I was asking for was reasonable.
Yeah.
I'm just concerned. So when it does come to October and I want to progress contact...
Yeah.
As I say, the judge did say that what I was asking for was reasonable.
Yeah.
At a child pace and in the child's best interest at their pace. Is if the mother... we can't come to an agreement with... the progression of contact in October. I'm concerned that I might get a barring order against me for making another application.
Well, no, you
12 months.
No, but I think listening to the history of what's happened and the context, I'm going to be honest with you. You're probably not going to succeed on the change of name application. The fact that that's been refused, I would leave that. If I were in your shoes, and just focus on the contact moving forward. Okay, choose your battles. Essentially, is what I'm saying. So focus on the contact. Now, if you and Mum cannot agree by way of a final order, because the court's ultimately wanting this out of the list. They want this application finished and off Judge's desk. But they can't do that without giving you guys a final order. And if you guys can't agree a final order, then the judge is going to list it for a final hearing and Judge is going to decide. So don't worry too much about making yet another application. Finish this one first. Okay? And there certainly won't be a barring application because you're in the middle of...
the parents can mediate. Is more pro mediation.
I accept that. I accept that, and a lot of judges will push parents to mediation because what they're trying to do is get them to co-parent. But all you need to say to the judges is, look, Judge, with the best will in the world, we're just struggling to mediate, unfortunately, and perhaps it's putting a strain on the relationship that's not needed. You know, sometimes just by giving parents a framework of contact and letting things settle down and just sticking to what the order says can be the best remedy. So if Judge is looking more towards, you having mediation, remember mediation is voluntary. You know, it's not compulsory. You can't force someone to do mediation. So I would just kind of keep it simple, focus on getting a final order in terms of the child arrangements. Any issues that you're having, let Judge know and be really honest about the mediation if it is or isn't working. You know, you don't have to put the other parent down. You can simply say, look, I'm giving it my best shot, but I just don't feel we're getting anywhere with the mediation.
Of course, because Kafkas even says that it would be in the child's best interest to have overnight contact.
Okay.
The judge was made aware of that. And says for free, it would be like 3 months down the line before overnights would start. So that is one thing I would need to mediate to that.
Are you still representing yourself?
Yeah.
Yeah. Okay. So what? Okay. I'm gonna jump in. I'm gonna jump in because I'm gonna give you a top tip. So when you were explaining the story to me, you gave me chapter and verse. Okay, you told me everything because, and I totally get why, because you think all of that's important. But for those litigants in person, like you are, what I would say is summarize the issues and just let the judge have them. Go into court with a piece of paper, just 3 things. Judge, we need help with this, this, and this. Because court won't necessarily want to know all of the backstory. And the reason for that is not because judge isn't interested, is because you could be case number 1304 that he's heard that month. Do you know what I mean? So what judge is trying to do is think, right, what are the issues that this couple need help with and what's in the child's best interests? All right?
Fantastic.
Good luck.
Definitely. That's why I usually do a position statement.
Oh, well done.
Start, just so
position statements are really helpful.
Yeah, so
okay.
I really appreciate that, Trace.
Pleasure.
Thank you.
All the best. Bye.
Bye-bye.
Right, Doodle, I'm going to come to you. We managed to get you up on the stage eventually. What's your question? Oh, you're on mute. Doodle, take yourself off mute. There we go.
Can you hear me now?
I can, yeah, loud and clear. How can I help?
Okay, it's just a quick one actually. So I use a parenting app.
Yeah.
With my ex-partner. We've been using it for maybe about a year now. What I find is he keeps saying the word compromise. So the compromises that he's asking for. So he sees our child every other weekend.
Yes.
But when he decides that he is not available, he doesn't tell me.
Okay.
Yeah, so it's a really weird one, and he always turns it round and would say things like, we'll just bring it back to court. It's called compromise. And I just find it really hard to, I completely grey rock it, and I just say, okay, that's fine, let's leave it at that. When will you see her?
Yeah.
But it's, yeah.
So it's no, I know, and look, what I will say is there's so many parents going through this. That is more of a co-parenting issue. That's more where he's insinuating that you aren't doing your bit and that you are the one that's being difficult, and you're the one that's putting blockers in his way. And of course, your perception of the situation is very different to that. So what I say then, it doesn't always work for every couple, but my recommendation is mediation, because a lot of times we haven't got safeguarding issues by the sounds of it, Doodle. You haven't told me that. You're happy for him to see her, but we have this co-parenting, this communication that is completely off kilter. What you're saying to him is not what he's hearing. And what he's saying to you is coming across as a little bit undermining, and you're feeling that, he's perhaps not making compromises. So if mediation doesn't work, in other words, you can't get past that communication barrier, unfortunately, a court application won't work either. So, he can make the court application, but essentially, if he's not sticking to the contact that's already been arranged, because that's all a court order is going to give you, isn't it? It's going to give you a framework of contact. It's going to lay out in black and white who the child lives with and how much time she has contact with dad. And that isn't going to help here. I think, what he maybe needs to shift his focus to is, how can I improve the co-parenting? Because how old is she? How old is your daughter?
She's 8.
So we've got another 10 years of this, essentially, before she's, good luck with that, before she's an adult. So, yeah, it's not really a legal issue. It's something that, you just have to try and navigate through either mediation or counselling sometimes, or, do you know what I mean? A court order's not going to help here, I wouldn't have thought.
Okay.
I'm so sorry. I don't know if that did help or not, but that's all I can think.
It's just one of those things. Continuously being like, they would say, oh, we'll just go back to court, and I'd say, okay, that's fine.
Yeah.
If you feel that I'm not following, but that's the thing, if it's like I'm the full-time parent, if I actually made arrangements on said weekend, and I was away, I don't know what I would have done, because I wouldn't have had my child. But I'm the one that's I'm the default parent at the end of the day, and I know that, and I choose to be that.
It's almost a power play in a lot of relationships where, you know, the other parent is expecting you to make all the compromise, and sometimes that comes from a place of anger because they aren't having the child as much as you are, so a little bit of jealousy there, and that backlash, do you know what I mean? And that's why sometimes counselling or mediation is the better route than going back to court, because all court's going to do as well is polarise those positions. It isn't helpful a lot of times.
Yeah, to be honest, when I went to family court, I had to really open up my mind to understand what their thinking was, and it's in the best interest of the child to see both parents.
Absolutely.
I now know that. Originally, my mindset wasn't that way.
Yeah. Oh, well, you've made a huge compromise then, by the sounds of it. You've really made progression. All right. Well, I'll leave that with you. I hope that helped. All right.
Yeah, lovely.
Okay, bye. Hi, Ed. How are you?
How are you? All right.
I'm good, thank you. How can I help?
Yeah, just a few points. So I've got an order in place already. It was put in place of October last year.
Yes.
Within the order, it states that father can have indirect contact by way of sending letters 6 times a year.
Yeah.
And mother assures the judge that she will periodically update father on child's well-being.
Okay.
Further bits that are relevant, but I'm a litigant person. I've not received any update whatsoever since the order's been made.
Yeah.
So I just want to go back and have it amended.
Yeah.
So I've done a C100 for that.
Yeah.
Would I be right in thinking to try and have the order enforced to ensure that it's not breached?
Well, so
but also what I want to be clear with is when I go back is to ask the judge if they can be very specific on what contact looks like in where form for father, so I can see. We all know when it's going to arrive, what it looks like, how I receive it, etc.
Absolutely, Ed. I mean, the first question that I had, you know, as a lawyer is, what does periodically mean? So I think where we're struggling as co-parents, we can't be doing with ambiguity. So periodical to one person could mean daily, to another it could mean weekly, or it could mean monthly. And issues around the child's welfare, what does that mean? You know, are we just talking about their medical, their health? Are we just talking about school reports or sports day? So I think you're right. I think it's not a breach, because the other side could argue that, we thought periodically was annually, or we thought it was every 6 months. So I don't think technically it's a breach, but I do think that it needs to be varied, because if you're feeling that, you know, it's not being adhered to because it's a little bit ambiguous, it's a bit vague, then absolutely we need some tightening around that. However, whilst you're waiting for that court date to come through, because again, this isn't a legal issue, this is more of an interpretation of the existing order. We were all interpreting it in different ways. So it might be that mediation helps actually to sit down and just get some help with between the two of you as to, well, what do you understand by periodically? What do you understand by it? And then what does she understand by it? And you know, specifically, I would like to be updated with regards to her parents' evenings or her sports days or her progress at school, but what does that look like? You know, so we don't always need to be running back to court. What you can do, and it may help, it may not, but it may help, is go onto the government website and download a parenting plan. And they're really detailed. CAFCAS do them as well. You can get them from CAFCAS website. They do them, and it's very specific questions that both parents have to answer. And what it's really good at as a document is showing parents how actually one word can mean two different things to two different people. So, because I'm sure the court will hear your application, it's going to take a little while, Ed, as you know, to get that hearing date. But in the meantime, because it's not a legal issue, try to maybe do some work, the two of you, to sort of narrow down what that language barrier, you know, what it means, what the order means to both of you.
Yeah, I agree. I think I do think in a certain degree it's sort of wasting court's time.
Yeah.
But it does need to be resolved.
Absolutely.
The issue with this also being is there's been claims of domestic abuse involved. So I do feel that a judge sort of needs to sort of, there is no ways of mediation.
Yeah. That definitely puts a different slant on it. That the fact that there's allegations raised. Okay.
Yeah. So and that brings me to the next point is where when I eventually go to the court, how would I go about asking the district judge to gain access to statements that were made to the police?
So you'd ask for a direction for police disclosure. So if the matter is going to proceed to what we call a fact find, where the court's going to test whether these allegations are true or false, there's usually a direction within the order that says the applicant has permission to obtain police disclosure, and that police disclosure must be filed and served. And you then file that court order with the police, and the police will then gather all of the records they have with your name, her name, your address, her address, whatever it might be. So it's a direction for police disclosure.
Brilliant. And just finally, when I submit my C100 application form and I filled it all out and I send it back to the court.
Yeah.
Do I need to also submit a C8 form with it? Do I send that form with the same email?
Yes, you do. And for those listening, a C8 is confidentiality. So it's where we don't want the court letting the other side know of our address. Absolutely, Ed. You need to file that with the C100, because if the court don't receive that C8, they're going to send your C100 out, or perhaps other documents out that has your address on.
Brilliant. Thank you so much. And
pleasure.
Thank you for everything you do. You're amazing.
Oh, pleasure. Thanks, Ed. Speak to you soon.
Bye-bye.
Bye. Kay, let me come to you. I'm just going to take you off mute. What's your question, Kay?
Hi, Tracy.
Hello.
Can you hear me?
I can, loud and clear.
Oh, brilliant. I got a financial order last year which forced the sale of the house.
Yeah.
And my ex is still living in the property, but I think he's dragging his feet, with the sale.
Yeah.
And I'm just wondering, what is my remedy? Because I moved out, and according to the order, I won't be able to claim any periodical payments orders and, adjustment orders. So, but I'm just wondering, if he's delaying, is there a case for occupational rent?
Well, what does the order say, first of all, Kay? That the house is to be sold?
Yeah.
And when is it to be sold?
It was said it needs to be put on the market forthwith, which it was.
Oh, it was,
So this is last year.
Okay,
yeah.
And then
this is the 28th of July.
And do you have contact with Do you have contact with the estate agents, Kay? Are they letting you know what's going on?
Well, yes.
Yeah,
kind of.
So
I had to kind of reiterate that I needed to be kept informed.
Sure. And are you having viewings? Has there been any offers? The reason I ask the questions is I'm trying to establish if there's actually a breach or not. So are people looking at the property?
Well, yeah, they are. And when people, like one person went round and they offered offered a certain amount.
Yeah.
And he said, no, I want this amount, X amount, but it was over the valuation.
Okay, so
property. Now I have gone back to the estate agent. And said, look, I'm willing to, look at a reduction. So can you speak to the ex, because the relationship was totally broken down, and
in the order, Kay,
there's nothing forthcoming.
So in the order, generally, in that order for sale paragraph, we will have, there's order for sale, house to be placed on the market forthwith, at a price to be agreed between the parties, and in default of agreement to be determined by the court. Do you have that clause in your order? It'll be sort of B. Yeah, and in default of agreement to be decided by the court. Because this oftentimes happens where, there's offers being received, but one or other of the parties won't accept them. And in that case, it's not a breach, but we have to go back to court to sort of say to the judge, we have this offer on the table. Here's 3 estate agents' valuations to say it's actually a decent offer and it should be accepted, but the other side are saying not to accept it. And then you'll get an order from the court that says, you know, any offers made in accordance with an estate agent valuation or for 350 or below, or whatever it might be. But what I'm saying is the court will give you more structure around the price of that it can be sold for. And it might be that you need to return to court to do that.
Okay, so which is the clause I'm looking for? Default of agreement?
So it should say order for sale. It should have a heading, order for sale. And then underneath that, it will say the property to be placed on the market forthwith at a price to be agreed between the parties, or if no agreement's reached, as per the court direction. Something like that. I tell you what you do, Kay, after the call, because I'm going to close up soon. If you have a look in my bio, you'll get my email address. If you want to email me a copy of that order, and I'll have a look for you, just remind me, because obviously I get a lot of emails. Just say you spoke to me on Discord on Wednesday, and that'll remind me. Take a quick look at the order for me, Trace, and let me know about the sale. That might be better.
Yeah, because we did agree an amount with the estate agent. So we have agreed that, but I can't see anything
in the order.
To say anything about
and it's one of those
of agreement.
Yeah, it's one of those where we're drafting the order in court. The day that we're drafting it, we want to be aware of any eventualities that may crop up if the other side are known to be difficult. And it might be that that's just been missed in the drafting of your order, but it's easily remedied. It's easily remedied.
Oh. All right, so it's just a default of agreement to go back to the court.
Yeah, so if you guys can't agree, then the court decide what it should be sold for.
Right.
All right.
We've got an agreement what it can be sold for. I think he just doesn't want to.
Well, you haven't,
commit to the
because I was going to say exactly. So there's no agreement really, is there?
Okay.
Technically there's not an agreement because you've had an offer and he's rejected it because he wants higher, and you're not in agreement with that higher price, so we don't have an agreement.
True.
All right. Okay. Fab. Thanks, Kay. Pleasure. Bye.
Thank you.
Guys, I'm going to leave it there. That was a busy first week back. Thank you, everybody. I appreciate there is still 2, 4, 6 hands left up. Let me tell you that I'm going to bob back on Friday afternoon at 12:30. You guys seem to like the daytime slots. Certainly suits me. I'm more than happy because I'm in the office anyway. So I'll be back here this Friday, which is the 2nd of August, and I'll do 12:30 till 1:30. So for those of you still with your hand up, I'm so sorry, but do come back and join me Friday, and hopefully then I'll be able to answer those questions. Until then, guys, thanks again. Thank you, Captain, for helping me earlier, and you, Mart. Appreciate that. Oh no, Mart's gone. Andrea, you're still there. Thanks as ever for my usual contenders. Until Friday then, take care, and I look forward to speaking to you then. Bye, guys. Guys, thank you so much, Instagram and TikTok. There was so many questions there. I'm so sorry I didn't even get to look at all of those questions. I did not expect Discord to be that busy. You heard what I just said. I'll bob back on Friday. But yeah, if you do have a pressing question, you know you can DM me. You know you can drop me an email. Or failing that, hop onto the Discord channel Friday at 12:30. But until then, take care. Bye, everyone. Bye. So guys, I hope you enjoyed that, and you know that if you have a pressing family law question that you want to ask me, you can also join me on the Discord. Obviously, we record it as you've just watched. I hope that you enjoyed that. So know that if you are going to bob onto Discord, we are going to then put them out on the YouTube and on the podcast. So links in the bio if you want to join me on the Legal Queen Discord, and don't forget, like and subscribe.